No, Your Honor.
Okay, let's go on the record on cause number DC 218670 Vieira, that's VIEYRA versus CSALIHU. Council, make your appearances.
This is Jennifer Alley with Daspit Law Firm, here for the plaintiff, April Vieira.
And Nick Vincent on behalf of the defendant, Hamid Salihu.
We're hearing a motion to reconsider. You may proceed.
Yes, Your Honor, and there's actually a motion to withdraw the deemed admissions that was also filed, and kind of whatever happens with the motion to withdraw the deemed admissions will have a direct effect on the motion to reconsider.
Mr. Vincent, I've read it. I guess my principal question is, why didn't you answer deemed admissions? This isn't a situation where you missed the deadline by a day or 2 days or a week. It was multiple months. What happened?
Yes, Your Honor, my client had the mistaken understanding that he could respond to discovery up until the date of trial. I've tried to explain this to him on multiple different occasions. But sometimes you can jump up and yell and scream as much as you want, and some of these things don't quite make it through to the client in their understanding of what is required of them. I was ultimately able to explain this to him and explain that we needed his responses in a timely manner when I was able to get him on the phone. My client is a busy man who works multiple jobs, drives Uber at night, and is a college professor. And he is at times difficult to get in touch with. And so in order for me to be able to explain to him that that was in fact not the case, it took me a little while to get him on the phone. And I wanted to withhold filing a motion to withdraw deemed admissions until I had the responses from my client in hand to be able to turn them over to plaintiff's counsel. This is not an instance where this was intentional or due to bad faith on the part of my client. This was not a conscious indifference or callous disregard of the rules of civil procedure. This was a mistake, Your Honor, and a mistake that he unfortunately believed until I was able to explain to him what has taken place thus far with the case and how that ultimately will affect his ability to defend this case. The remaining arguments that I have with regards to that, on top of the fact that this was just a mistake, is that this will not unduly prejudice the plaintiff to undeem these admissions. They've known our defenses since our general denial. They've also known our defenses since Mr. Salihu's deposition. And Mr. Salihu, at his deposition, plaintiff's counsel could have asked him about these deemed admissions and built a record on their bad faith argument and built evidence as to the fact that this was all in bad faith or callous disregard. This was after the deadline. Plaintiff's counsel did not ask him any questions about that. It was my understanding after speaking with him that he understood what I was telling him about our deadline. But not until later did I find out that he mistakenly believed that they were due at a later date. My client is not original to and wasn't born and raised in the United States. English is not his first language. And sometimes there is a loss in the translation between myself and my client.
Response.
Well, the deposition of his client took place after the admissions were already due, in response to his argument saying that I could have brought it up at the deposition. So I couldn't have told him about his upcoming deadline because it had already passed at that point. Further, it's not really my responsibility to alert the defendant about his upcoming deadline. That's his counsel's job to do that. As for, I can make an argument that there was a callous disregard for the rules. Defendants didn't serve the responses until after this court granted the partial MSJ. That was 172 days after the due date. That's an egregious amount of time in between whenever the responses were originally due and when I was finally served with them. Further, defense counsel had the request for 233 days. That's not even counting the day that they were served on the defendant. As for the undue prejudice, they served the responses 22 days before the close of the discovery period. That doesn't even give me enough time to supplement discovery requests based on the responses I received on the day of the MSJ hearing on September 12th. Further, there's no good cause for withdrawal because the party was alerted of their admissions being deemed when I filed the MSJ on May 25th, 2022. They were notified that they had not responded to my requests, and they didn't serve responses until 110 days after learning of the unanswered requests. And further in the hearing, they stated that they had the responses, they got them Friday from the defendant. However, they never served them to me until after the hearing happened. If this situation is not the situation where this rule is enforced, what facts would the court need to enforce it, is my question to the court. And plaintiff asked the court to deny defendant's motion to withdraw the deemed admissions and uphold the partial summary judgment in plaintiff's favor.
I mean, she does make a compelling argument in that there was a summary judgment based on deemed admissions, and there wasn't even a request to undeem them. When did the client know that the summary judgment was? I guess I'm not really clear on the timeline here of when the client kind of came to the realization that they had to answer this. And I guess I kind of agree with her. Like, the client has basically said, against the advice of counsel, hey, I don't have to comply with the rules. And I get that. I mean, we got to treat
just
everybody.
Briefly responding to that, Your Honor, my client has not said that. That they have the burden of showing that if that's the route that they're going, that my client had a callous disregard of the rules of civil procedure and that this was in bad faith. I'm explaining to the court that my client had a mistaken belief. He did not have. This was not in a belief that he was going through with callous disregard of the rules of civil procedure. Not until I was able to speak with him, which was 2 weeks prior to our motion for summary judgment hearing, I told him that I needed the responses as soon as possible. We got the responses and obviously needed to document them and type them up and get them ready for service. And that took us a little bit of time, but that all happened before the motion for summary judgment was heard. But I did not want to make a motion before the court for undeeming those admissions before I actually had the admissions in hand to serve on the plaintiff, because I wouldn't be able to ultimately go through with the effects of the motions to undeem without those responses. And so this is not a situation where it's callous disregard of the rules of civil procedure on the fact of my client. It's that he had a mistaken belief on when they were due. And
But you advised them when they were due, right?
I advised him on when they were due, but again, my client is not.
He disregarded that, didn't he?
He didn't disregard it, Your Honor, but sometimes you hear what you want to hear. And so he ultimately believed, based on our discussion, that they were due at a later date than they actually were. It's not like he just had a conscious disregard of my comments to him. It's that he misunderstood my comments to him. And my additional argument will be that with these deemed admissions, this is a a complex multi-defendant case that's going to go before the jury, there are many things that need to be decided by the jury, not only negligence, but the percentage of negligence that's placed on each defendant. By granting these or denying our motion to withdraw, it pulls that and precludes the jury from being able to consider any of those facts. And it makes it an instance where this is pulled from the hands of the jury, and they are not going to be able to decide the important issues of this case, which also comes down to
that's how admissions work. I mean, you're basically saying, I mean, talk to the Supreme Court. They're the ones who adopted the procedure of request for admissions. I mean, you're basically arguing against the entire civil justice or civil rules of procedure there.
No, I'm not, Your Honor. I'm just saying that they haven't met their burden on proving that this was flagrant bad faith or callous disregard.
I mean, I'm more focusing on what you said, which is you told them they were due, and I mean, I don't know. I mean, I very rarely actually decline to withdraw deemed admissions, because I agree with you. It's a high standard, and I tend to want things to be decided on the merits, but I'm concerned in this situation where you have a client who is being told by a lawyer, you need to get these in, you have a summary judgment pending, you've said it, he knew that, all that stuff, and he still refused to get them in. I kind of agree with Mr. Ali. What else would it take? I mean, to show callous disregard when you're being told by your lawyer they're due, you have a summary judgment pending, it's going to resolve issues, and then I mean, is the rule, should the rule be that if you don't have a complete understanding of English, you get a free pass every time? I'm not sure that that's what's contemplated by the rules. I don't know, Ms. Reale, what do you think?
I definitely don't think that he should get a free pass just because he doesn't completely understand English. And there is a Dallas appellate case from 2020, Torres v. Lee, that talks about the callous disregard and bad faith. And in that case,
on the dialogue.
in that case, they they quote a couple of other cases, but they mentioned that 3 months after being put on notice that the admissions were deemed admitted, which I would argue that happened on May 25th when I filed my motion for summary judgment on the basis of deemed admissions. Taking 3 months to remedy that was too long. And it presented a callous disregard for the rules, because they shouldn't have taken that long. It should have been an immediate reaction to try to fix the mistake. Instead, they just took their time. And further, he was presented for deposition in April, a month after these responses were originally due. And he couldn't talk to his client then. He couldn't get him on the phone then. He was able to present him for a 2.5 hour deposition, but he couldn't talk to him and urge him to give me my responses then. That's my question for him, for defense counsel.
I'm not as concerned about the deposition issue. I am concerned that the summary judgment was filed and you had 3 months to get it remedied. Why did it take so long?
Because, Your Honor, as I've stated previously, my client is difficult at times to get in touch with. It is not a streamlined, seamless ability to get him on the phone. He works multiple jobs. He's a college professor who is constantly teaching or driving for Uber or studying for future exams to further himself. And he is not the easiest person to be able to get on the phone and call up and say, hey, I need these responses immediately. It took time, and it unfortunately took time for me to be able to get him on the phone and to explain this to him. And as soon as I did, we got the responses, and we got them over.
Well, you said it. You talked to him 2 weeks prior to the hearing, yet he didn't get you the responses during that 2 weeks.
He did, Your Honor. He got me the responses. We drafted them up, and it took us a little bit of time to do that. But we did have the responses ready to serve on plaintiff's counsel before the motion for summary judgment.
But you didn't. I'm a little confused about that. You did, but you didn't file them. It would seem like you would have wanted to have filed those responses before the hearing occurred, right?
Yes, Your Honor, and we attempted to try to do that. I talked to him the timeline is I talked to him 2 weeks before the hearing. He told me he would give me the responses. He got me the responses on Thursday before our motion for summary judgment. My paralegal was out of the office that Thursday. On Friday, we wrote them up. We served them on the day of our motion for summary judgment later in the afternoon.
Ms. Reale, when did you get the responses? Was it before or after the hearing?
It was after the hearing. It was at 1:32 p.m.
I'm not going to rule on this for now. I really do want to kind of hear from your client and get a feel for what, maybe reset this if you want to. And I want to hear from him exactly what his thought process was, why. I mean, he's a professor. He should be able to speak English well enough to understand these are due. I have to get them in. Maybe there's just something I'm missing, but I'm willing to discuss reconsideration of this after talking directly to the client and figure out what happened here. This doesn't seem make a whole lot. Doesn't make a whole lot of sense. It does seem it really does seem like this is callous disregard by your client, but I guess I'd probably want to hear from him before I make a final decision. So I'm not going to rule on this. When is the trial setting?
January 17th, 2020.
Yeah, so you have some time to try to get a hearing, and let me speak to him about it. And we could have an evidentiary hearing, or we can have or you can, Ms. Rowley, would you rather take his deposition?
Like retake it, because
On the limited issue of the callous disregard. Or do you want me to just have an evidentiary hearing?
whatever's easiest for you, Judge.
It's your call.
Um,
It might be easier for you to just do an evidentiary hearing, but if you want to do deposition, you can too.
let's do the evidentiary hearing.
Okay. Mr. Vincent, just go ahead and reset this once you talk to your client, explain to him the severity of this, and we'll go ahead and reset this once you get a date set with your client. And don't set this with my associate judge. Set this particular hearing with me.
Yes, Your Honor.
Other hearings you can set with her, but don't set this hearing. All right. Thank you so much, guys. You have a great rest of your day. Okay.
All right.